When the Department of Justice unseals classified materials in an ongoing investigation, the action carries weight that extends far beyond the immediate case. Federal prosecutors do not release sensitive documents without careful legal review, multi-level authorization, and confidence that transparency serves the public interest. These are not political gestures. They are procedural steps rooted in statutory obligation and constitutional accountability. Donald Trump now faces a situation where previously sealed documents have been released to the public, and the contents have sent shockwaves through legal and political circles. Court filings, financial records, and witness testimony that were once protected under seal are now accessible for scrutiny. The timing is critical, the details are damaging, and the legal exposure is mounting. This is not simply another controversy in a long series of disputes. This represents a convergence of evidentiary disclosure, prosecutorial strategy, and constitutional accountability that places the former president in territory few American leaders have ever occupied. The rule of law does not pause for political convenience, and what these documents reveal will shape the trajectory of multiple ongoing investigations. The unsealing order came from a federal judge presiding over cases tied to classified document retention, obstruction of justice, and potential violations of the Presidential Records Act. According to court records, the Department of Justice argued that continued sealing was no longer justified given the public interest in transparency and the advanced stage of the investigation. The judge agreed, ruling that the materials must be made public with minimal redactions. What emerged from those unsealed files is a detailed accounting of conduct that legal experts describe as deeply problematic. Financial records show patterns of unreported income tied to foreign entities. Witness statements describe deliberate efforts to conceal materials from federal investigators. Communications between legal representatives and third parties suggest coordination to obstruct lawful inquiries. This is not speculation. These are sworn statements, documented transactions, and timestamped communications now part of the public record. The Department of Justice does not unseal documents lightly. Prosecutors understand that premature disclosure can compromise ongoing investigations, endanger witnesses, or prejudice potential jury pools. The decision to release these materials signals that investigators believe their case is sufficiently developed to withstand public scrutiny. It also suggests that the evidence is strong enough that transparency will not undermine prosecution efforts. Key players in this unfolding crisis include Special Counsel Jack Smith, who has led multiple federal investigations into Trump's conduct. Smith has a reputation for meticulous case construction and aggressive pursuit of accountability. His office coordinated the unsealing request, indicating that these documents serve prosecutorial objectives rather than undermine them. That is a significant strategic signal. Also central to this moment is Judge Aileen Cannon, who has presided over portions of the classified documents case. Her rulings have been scrutinized for perceived delays and deference to defense motions. However, the unsealing order did not come from her courtroom. It came from a different federal judge overseeing related matters, suggesting that prosecutors sought a venue where transparency would be granted without prolonged procedural resistance. Members of Congress, particularly those serving on oversight committees, have already begun referencing the unsealed materials in public statements. Representative Jamie Raskin, a constitutional scholar and ranking member on the House Oversight Committee, described the documents as revealing a pattern of conduct that cannot be reconciled with lawful behavior. Senator Sheldon Whitehouse, who chairs the Senate Judiciary Subcommittee on Federal Courts, noted that the financial disclosures alone warrant further congressional inquiry. The initial evidence contained in the unsealed materials falls into several categories, each carrying distinct legal implications. First, there are financial records showing millions of dollars in transactions routed through limited liability corporations with foreign registration. Federal law requires that income derived from foreign sources be reported to the Internal Revenue Service, particularly when the individual holds or has held federal office. These records suggest systematic non-compliance with disclosure requirements spanning more than a decade. Second, the documents include testimony from a former attorney who represented Trump in negotiations with federal investigators. That attorney, under oath and facing potential disbarment proceedings, stated that he was instructed to mislead the FBI regarding the location and volume of classified materials stored at Mar-a-Lago. He described being told to certify compliance with subpoenas when he knew personally that documents remained hidden. Obstruction of justice is a federal felony. Suborning false testimony compounds that exposure. Third, communications between Trump and advisors reveal discussions about moving materials between properties to avoid detection by federal agents. Text messages, emails, and recorded phone calls describe logistical coordination designed to keep certain boxes out of investigator reach. One message, sent just days before a scheduled FBI visit, reads, "Make sure the storage room is clear before they arrive." Another states, "He wants everything moved to Bedminster tonight." These are not ambiguous statements. They reflect deliberate intent to frustrate lawful search and seizure. Add to this the testimony of multiple witnesses who worked at Trump properties during the relevant time frame. Housekeeping staff, security personnel, and maintenance workers all provided statements describing unusual activity in the days surrounding federal inquiries. Boxes were relocated, access to certain areas was restricted. Instructions were given to avoid discussing specific rooms with anyone outside the immediate circle. When investigators later executed search warrants, materials were found in locations that had previously been declared empty. The legal framework governing classified document retention is unambiguous. The Presidential Records Act mandates that all materials created or received by a sitting president in the course of official duties become the property of the National Archives upon leaving office. Unauthorized retention of such materials is a criminal violation. Obstruction of efforts to retrieve those materials escalates the offense significantly. The unsealed documents provide a roadmap of both retention and obstruction, documented in real time through communications and corroborated by witness testimony. Meanwhile, financial exposure extends beyond simple non-disclosure. Federal tax law requires that all income, regardless of source, be reported. When income flows through offshore accounts or shell corporations, the burden of proof shifts to the taxpayer to demonstrate that reporting requirements were met. Forensic accountants working with the Department of Justice have traced payments totaling over $200 million that appear nowhere on filed tax returns. The IRS has flagged these discrepancies, and criminal referrals have been made to federal prosecutors. Legal analysts, including former federal prosecutor Glenn Kirshner, emphasize that the combination of classified document violations and financial crimes creates a prosecutorial advantage. These are separate offenses, each carrying significant penalties, but when combined, they present a pattern of conduct that undermines any defense based on inadvertent error. Kirshner notes that prosecutors will argue this reflects a lifestyle of impunity, where rules are treated as optional and accountability is something that applies to others. The consequences of this evidentiary disclosure are immediate and far-reaching. Defense attorneys must now contend with a public record that contradicts prior assertions made in court filings. Claims that all documents were returned, that cooperation was complete, and that no obstruction occurred are now demonstrably false based on the unsealed materials. Judges do not respond kindly to counsel who mislead the court, even when acting at a client's direction. Sanctions, disbarment, and contempt findings are all within the realm of possibility. Politically, the impact is equally severe. Republican lawmakers who have defended Trump's document retention as a minor procedural matter now face evidence showing deliberate concealment and coordination to obstruct federal agents. Swing district representatives, particularly those in constituencies where rule of law messaging resonates, are distancing themselves from blanket defenses. Senator Mitt Romney, who has broken with party orthodoxy on Trump-related issues before, stated publicly that the unsealed evidence is deeply concerning and warrants full accountability. This matters because political cover is eroding at precisely the moment when legal jeopardy is intensifying. Trump has relied on party loyalty to insulate him from consequence. When that loyalty fractures, as it is beginning to now, the insulation weakens. Prosecutors are emboldened. Judges are less deferential. Witnesses become more willing to cooperate when they perceive that the subject of the investigation is increasingly isolated. Compounding this pressure is the timeline. Multiple trials are scheduled for the coming months, and the unsealed documents will inform jury selection, evidentiary motions, and prosecutorial strategy in each of those proceedings. Defense attorneys must now prepare for cross-examination based on materials they may have hoped would remain sealed indefinitely. Prosecutors, by contrast, can structure opening statements around documents that jurors can read themselves. That evidentiary clarity favors the prosecution substantially. What makes this even more destabilizing is the overlap between federal and state proceedings. While the Department of Justice pursues federal charges related to classified documents and obstruction, state prosecutors in New York and Georgia are advancing cases tied to financial fraud and election interference. The unsealed federal documents provide evidentiary support for some of those state cases, creating a synergy where victories in one jurisdiction bolster arguments in another. The focus now rests on whether additional unsealing orders will follow. Federal investigations produce vast quantities of materials, much of which remains under seal during active proceedings. If prosecutors believe that transparency serves their case, they will seek to release more. Each new disclosure adds weight to the cumulative case against Trump, making it harder for defense counsel to argue that allegations are speculative or politically motivated. Add to this the international dimension. The unsealed financial records show transactions with entities tied to Saudi Arabia, Russia, and China. These are not business dealings conducted prior to political office. Some of these payments occurred during Trump's presidency, raising questions about compliance with the Emoluments Clause of the Constitution. That clause prohibits federal office holders from accepting payments from foreign governments without congressional consent. There is no evidence that such consent was ever sought or granted. Investigators describe the financial structure as deliberately opaque, designed to obscure the origin and destination of funds. Offshore accounts, shell corporations with minimal operational activity, and transactions routed through multiple jurisdictions all suggest intent to avoid scrutiny. Forensic analysis reveals that money flowed in during periods when policy decisions favorable to the paying nations were being made. Causation is difficult to prove, but the correlation is striking and will be presented to juries as circumstantial evidence of corrupt intent. Courts assess evidence based on weight and credibility. When financial records, witness testimony, and documentary communications all point in the same direction, juries are inclined to find the pattern persuasive. Defense attorneys can challenge individual pieces of evidence, but when the pieces fit together into a coherent narrative, the defense burden becomes much heavier. What the unsealed documents provide is precisely that coherence. Evidence reviewed by lawmakers suggests that the obstruction was not improvised. It was systematic, involving multiple individuals and spanning several months. Legal counsel, political advisors, property managers, and family members all participated in moving materials, altering records, and providing false assurances to investigators. Conspiracy to obstruct justice is a charge that prosecutors will likely pursue, and the unsealed materials provide the foundation for such a charge. The record shows that federal agents attempted to negotiate voluntary compliance for months before resorting to search warrants. Subpoenas were issued, extensions were granted, assurances were provided that cooperation would be met with prosecutorial discretion. Instead, materials were hidden, statements were falsified, and obstruction continued. That pattern of defiance will weigh heavily in sentencing considerations if convictions are secured. Documentation reportedly includes time-stamped security camera footage from Mar-a-Lago showing boxes being moved in and out of storage areas during the window when investigators were seeking compliance. This is not testimony that can be challenged through cross-examination. It is video evidence, time-stamped and date-stamped, showing physical movement of materials at moments when cooperation was supposedly complete. Defense attorneys will struggle to explain why such movements were necessary if nothing was being concealed. Analysis of the filings reveals that prosecutors have built redundancy into their case. Even if certain evidence is excluded on procedural grounds, alternative evidence establishes the same facts. If witness testimony is challenged, financial records corroborate the claims. If communications are disputed, video footage provides independent confirmation. This redundancy reflects sophisticated trial preparation and suggests confidence that convictions can withstand appellate scrutiny. Everything is happening at once. Federal investigations are advancing toward trial. State cases are proceeding in parallel. Congressional oversight committees are issuing subpoenas based on the newly unsealed materials. Public opinion, even within traditionally supportive constituencies, is shifting as evidence becomes accessible. Republican primary challengers are beginning to use the unsealed documents in campaign messaging, arguing that Trump's legal troubles make him unelectable in a general election. Courts are functioning as designed, judges are enforcing orders, prosecutors are presenting evidence, defense counsel are being held to standards of candor. The machinery of accountability, though slow, is operating. That is both reassuring and destabilizing. It is reassuring because it demonstrates that institutions can withstand political pressure. It is destabilizing because the cumulative weight of multiple proceedings creates a crisis atmosphere where outcomes are uncertain and stakes are extraordinarily high. Congress is responding with renewed urgency. Oversight hearings are being scheduled. Subpoenas are being drafted. Witnesses who previously invoked privilege are being recalled under threat of contempt. The unsealed documents provide a factual foundation that makes congressional inquiry more focused and legally defensible. Lawmakers can point to specific transactions, specific communications, and specific acts of obstruction when framing questions. That specificity makes evasion more difficult and perjury more detectable. Public opinion is also shifting, gradually but measurably. Polling conducted after the unsealing shows that independent voters, particularly those in suburban swing districts, are increasingly uncomfortable with the pattern of conduct revealed in the documents. These are not voters who follow political news obsessively, but they respond to clear evidence of wrongdoing. When financial crimes, obstruction of justice, and classified document violations are documented in official court filings, the perception shifts from partisan dispute to criminal accountability. Party defections are beginning to emerge. Republican senators who face re-election in competitive states are declining to defend the conduct described in the unsealed materials. Some are calling for full cooperation with investigators. Others are suggesting that Trump should withdraw from the presidential race to focus on his legal defense. These are not dramatic denouncements, but they represent a weakening of the unified front that Trump has relied upon to deflect accountability. Financial exposure continues to grow. Asset seizure motions have been filed in connection with tax evasion charges. Liens are being placed on properties tied to unreported income. Forensic accountants are tracing money flows through corporate structures that were designed to obscure ownership and control. The exposure is not merely reputational, it is financial, with potential consequences that include forfeiture of assets, penalties totaling hundreds of millions of dollars, and personal bankruptcy. Constitutional mechanisms designed to enforce accountability are being activated. The 25th Amendment, though not directly applicable to a former president, has been invoked in congressional discussions about fitness for office. The emoluments clause is being cited in civil lawsuits seeking damages and injunctive relief. The Presidential Records Act is the statutory foundation for criminal charges. These are not abstract principles. They are enforceable legal standards, and enforcement is underway. The walls are closing in, not as a rhetorical device, but as a factual description of the legal situation. Every avenue of defense is narrowing. Every procedural delay is being exhausted. Every argument that previously provided cover is being undermined by newly disclosed evidence. This is not speculation. This is the documented progression of multiple criminal investigations reaching critical stages simultaneously. Options are narrowing. Plea negotiations have reportedly been explored and rejected. Cooperation with investigators in exchange for leniency has been declined. Legal strategies based on executive privilege have been rejected by courts. Appeals are pending, but appellate courts have shown little inclination to reverse trial court rulings based on the strength of the evidence. The path forward from a defense perspective is increasingly unclear. Time is running out for legal maneuvers that could forestall accountability. Trial dates are approaching. Jury selection will begin soon. Once juries are impaneled, the focus shifts entirely to evidence presented in open court. The unsealed documents will be exhibits. Witnesses will testify under oath. Cross-examination will occur in real time. The controlled environment of legal filings and press conferences gives way to the adversarial rigor of a criminal trial. This situation has not been seen since Watergate. The convergence of criminal investigation, congressional oversight, judicial enforcement, and political isolation mirrors the final months of the Nixon presidency. Legal historians draw parallels between the release of the Watergate tapes and the unsealing of Trump documents. Both moments represented evidentiary breakthroughs that shifted the landscape from accusation to documentation. Both made denial untenable and accountability inevitable. As legal analyst Glenn Kirshner has emphasized, the rule of law cannot function if it applies selectively. When evidence of criminal conduct is this extensive, this well-documented, and this publicly accessible, failure to prosecute would undermine the foundational principle that no one is above the law. Kirshner notes that prosecutors have an obligation not just to pursue charges, but to pursue them vigorously and without regard to the political identity of the accused. That obligation is being met in this case, and the unsealed documents provide the evidentiary foundation that makes conviction achievable. The coming weeks will determine whether American institutions can withstand this constitutional stress test. Courts will rule on motions, juries will be selected, trials will begin, evidence will be presented, verdicts will be rendered. This is not a political process subject to spin and narrative control. This is a legal process governed by rules of evidence, standards of proof, and the judgment of ordinary citizens serving as jurors. History is watching. The precedent being set here will shape how future presidents understand the limits of executive power, the obligations of public office, and the consequences of defiance. If accountability is achieved, it will reinforce the principle that democratic governance requires submission to law. If accountability fails, it will signal that power can insulate individuals from consequence, regardless of the evidence. This story is far from over. The unsealed documents represent one chapter in a longer narrative of investigation, prosecution, and judgment. More disclosures will follow, more witnesses will testify, more evidence will emerge. The trajectory is clear, even if the ultimate outcome remains uncertain. What is certain is that the legal system is functioning, that evidence is being gathered and presented, and that accountability mechanisms are operating as designed. We will continue tracking every development as this historic case unfolds. Every court filing, every witness statement, every judicial ruling will be analyzed and explained. If this analysis helped you understand the legal and constitutional stakes of this moment, subscribe for continued fact-driven coverage. Turn on notifications so you don't miss critical updates as trials approach and verdicts are rendered. The rule of law is being tested, and how this test concludes will define the strength of American democracy for generations. This story is far from over.